Welcome back to the Cabargo IT 2026 PI Law Technology Series. I'm Amelia Pero. Today's episode is probably the one that will keep the most PI partners up at night, the regulatory and compliance landscape around AI in law firms. Yuval Gorin from Cabargo IT is here with me. And while he's not a lawyer, doesn't play one on TV, and this isn't legal advice, he's going to walk us through the compliance framework every PI firm needs to understand. Yuval, welcome. Where do we start? How complex is the regulatory environment for AI in law firms right now? Give us the honest answer.
Well, it's genuinely complex and getting more complex by the month. That's not to be meant to be alarmist. It's just the accurate description. Here's the challenge. There's no comprehensive single federal AI law for law firms. What you have instead is a patchwork. HIPAA applies because you're handling medical records. The FTC safeguards rule applies because you're handling financial info. State privacy laws apply, and there are now active AI specific or privacy laws, California, Colorado, Texas, Utah, Illinois, Florida, and others. And on top of all that, your state bar association has ethics opinions about AI use that create professional conduct obligations. Each of those layers have different requirements, different enforcement mechanisms, and different timelines. Texas's TREGA, for example, goes into effect in 2026 and has specific restrictions on how AI can be used in decision making. California and Illinois prohibit using client case data to train AI models without explicit consent. Arizona and Utah have regulatory sandbox programs that allow more innovation but require written policies and client opt outs. If your firm operates in multiple states, and many PI firms do, especially in broader markets, you have to map all those requirements and comply with the most stringent standard in each jurisdiction.
You mentioned bar ethics opinions. What are the bar associations actually saying about AI?
The bar opinions are converging on a few consistent themes, and I'll summarize them this way. You are responsible for everything that comes out of your firm, including AI outputs, and the AI did it is not a defense. More specifically, bar opinions are emphasizing four obligations. First, competence. You have a professional obligation to understand the tools you use. You don't need to understand the machine learning architecture, but you do need to understand what the tool does, what its limitations are, and when to distrust its output. Secondly, confidentiality. You cannot send client information to AI tools that will use that information to train their models or share with other users. This is the one that trips people up the most because consumer AI tools, like the free tiers of various platforms, often do use your inputs for training. Let me also say, if you're using the free tools on your personal stuff, you want to really limit what you're putting out there. Thirdly, supervision. AI outputs require attorney review. You cannot submit a brief, a demand letter, a research memo that was AI generated without a licensed attorney reviewing and taking complete responsibility for that content. Lastly, disclosure. Some jurisdictions are moving forward with requiring you to disclose to clients when AI was used in their representation, particularly for sensitive tasks. That landscape is still evolving, but the direction is clear. I will add that even if your state or bar association doesn't mandate it, you need to give clients an opportunity to opt uh, out of you using AI in their case.
Okay. Let's talk about the vendor versus deployer responsibility framework you describe in the report. How does accountability get divided?
The emerging framework from regulators and bar associations is shared responsibility. Vendors are expected to build safe and secure tools, but the law firm, as the deployer or user of the tool, is accountable for how the tool is used in practice. Even if the vendor's tool malfunctions, even if the vendor has a security breach, the firm's clients look to the firm for accountability. The analogy I use is if you hire a temp worker through a staffing agency, the agency screen them, but if they do something wrong in your office, your clients aren't going to the staffing agency, they're coming to you. So, what does deployer accountability look like in practice? You vet every AI vendor before you adopt a tool. You verify their security certifications, SOC 2 Type 2 and ISO 27001 are the bars to clear. You confirm they have data isolation, meaning your client data doesn't get used to train their model for other customers. You must get a business associates agreement, BAA, if the tool will process any health information. And you document all of that due diligence because in a bar complaint or malpractice claim, your documentation is your defense.
Yeah, what's the biggest compliance mistake you see PI firms making right now?
Using consumer AI tools with client data, full stop. This is happening at almost every firm we talk to, and most of them don't know they're doing it. An attorney copies a client's medical summary into ChatGPT, the free version, or even their own personal version, to ask it to summarize or analyze the content. That data is now in OpenAI systems, and depending on the terms of service at the time, it may be used for model training. That's a potential HIPAA violation. It's a potential bar ethics violation, and it's a breach of client confidentiality. The fix is not complicated. Use enterprise tier tools with data protection agreements in place. Microsoft Copilot with a Microsoft 365 business subscription has data protection built in. Claude for Enterprise has appropriate data protections with a BAA. Many of the legal specific AI platforms are built with this in mind. But you need a policy that says these are the approved tools, these are the prohibited tools, and here's why. And you need to train every attorney and staff member on that policy because the attorney who's doing the most creative work with AI is often also the one most likely to be experimenting with unapproved tools. We need a methodology for uncovering AI usage that is not sanctioned or under license with the PI law firm.
All right. So give us the five pillar compliance framework from the report, the practical checklist, if you will.
Well, here's the framework. As you mentioned, five pillars, each one non-negotiable. Pillar one, data privacy and security. Client data needs to stay isolated. No public AI models with client information. Encrypted platforms, verified vendors, complete secure data practice. Pillar two, client consent and transparency. Clients are informed when AI is being used in their presentation, especially for sensitive tasks. You have a process for documenting that disclosure. Pillar 3, AI vendor and tool vetting. Every tool gets evaluated before adoption. SOC 2, ISO 27001, BAA availability, written documentation of that evaluation. Pillar 4, lawyer supervision and training. Every AI generated output must be reviewed by a licensed attorney before it goes anywhere near a client or a court. Staff are trained on what AI can and can't do and on the firm AI policy. Pillar 5, monitoring and audit of all AI outputs. You have a scheduled process for reviewing how AI is being used in your firm, catching errors, and updating your practices as the technology and regulatory compliance evolves. If you build those 5 pillars into your operations before you go all in on AI adoption, you're going to be in a much stronger position legally, ethically, and competitively.
Yeah, this is such an important framework. Coming up next, we are shifting from compliance to opportunity with a deep dive into KPIs and dashboards, how PI firms are using data to manage performance, prepare for PI scrutiny, and make smarter decisions. See you in episode 6.